Good morning, house guests. And for those of you in the Netherlands, I hope I caught you. So we are here doing a live, and we're just going to be reading over Jennifer Abel's response to sanctions, along with some of the exhibits that she had included in her response. And one of these exhibits is really quite interesting, and I have a lot of questions, and I'm wondering if this has been brought up before and I just missed it, or if this has been kept under wraps and now it's getting out because Blake Wiley wants to punish Jen Abel. So they write, "Dear Judge Wyman, Plaintiff Blake Lively asks this court to impose monetary sanctions against defendant Melissa Nathan." I'm sorry, I said Jennifer Abel. This is Melissa Nathan. "Pursuant to Federal Rule of Civil Procedure for failing to provide unredacted copies of 38 documents in alleged violation of the court's August 27, 2025 order on Lively's omnibus motion to compel, docket 711. Specifically, Lively asked the court to order Nathan to produce the challenged documents, the 38 documents listed in Exhibit A to the Bender Declaration, without redactions within a week of the court's order, and reimburse Miss Lively for reasonable attorney's fees and expenses incurred by Miss Nathan's failure to comply with the order." Nice. Okay. Plaintiff's motion for sanctions fails for the simple reason that it does not stem from the violation of any court order. I'm so sorry. I didn't mean to mute you guys. Let me read this last paragraph over again, just in case you missed it on my mute. I am terribly sorry. Plaintiff's motions for sanctions fails for the simple reason that it does not stem from the violation of any court order. A district court may only impose sanctions under Rule 37B for noncompliance with a clearly articulated order of the court requiring specified discovery. Sorry, just missed my place. With specified discovery, and then it gives a case, and then another case. Rule 37B, sanctions require the violation of an explicit court order, is basically what this case law says. The order required the wayfarer parties to modify the redactions in their previous productions to replace black box redactions with text box redactions indicating the reason for the redaction, i.e., redacted privilege or redacted NR, docket 711, pages 2 to 3. It is undisputed that Nathan did so on August 13, 2025, before the court ordered deadline of September 2nd. The wayfarer parties, including Nathan, reproduced all documents previously redacted in the properly required format, noting the reason for the redactions. Ooh, wayfarers pointing out Lively. Okay. Lively argues that in addition to requiring the wayfarer parties to reproduce redacted documents with a notation reflecting the reason for the redaction. The order also required Nathan to produce 38 documents without any redactions at all. But the order does not compel Nathan to remove the redactions on any of the documents she had previously produced, let alone require the production of the specific 38 documents Lively now seeks to compel in an unredacted format. Basically, she has all that she needs. Here's a footnote, and we love footnotes. Exhibit A to the Bender Declaration purports to list the documents Lively contends were improperly redacted, which she called the challenged documents. While there are 39 documents on this list, 2 of the documents are identical, which is Nathan 00002016. Footnote number 2. Lively states that the documents were reproduced on August 14th, docket 901, page 2. But in fact, they were produced a day earlier on August 13, 2025. So again, it seems like Lively is getting her dates mixed up. I continue on to the second page. Nor does the order state that any of Nathan's redactions were improperly overbroad. Articulated order of the court requiring specified. Oh, I'm sorry. I totally skipped that program. This is not surprising because Lively never made any such argument, nor did she request that Nathan produce the 38 challenge documents without redactions in her omnibus motion to compel. Oh, so basically, I think maybe she's just throwing a fit because she's got nothing and she needs her money back because she spent all of her money and all of her movie money on this, my opinion only. Therefore, Lively sanctions motion must be denied because there is no clearly articulated order of the court requiring specified discovery, which would permit the imposition of Rule 37B, sanctions for noncompliance with that order. So they can't really punish her for anything, is what they're saying, at least in my opinion. I continue. Lively sanctions motion is a thinly disguised, untimely motion to compel. In Lively's own words, it is well settled that the operative time to raise and move on discovery issues is before the close of fact discovery. Benson Declaration X2, they give a reference. And then some more case law. Let me find a lot of case law. Okay. The court's deadline of close of discovery had been clearly set as September 30, 2025, docket 425. Lively first raised the issue regarding Nathan's redaction on September 23, over a month after the Nathan documents had been reproduced with the proper notations. Does anybody think that maybe they're losing track of all of these redactions and notations and evidence because Blake Lively is on a quick, hey, let me just file with the court back to back to back to back to back? So maybe she's like ADHDing everybody, and so maybe they're missing things that they've already had. Because now this just maybe looks a little bit disorganized, or it just looks like a flat out lie, and I hope that they're just disorganized. But this is Blake Lively, so everything is unexpected. Been reproduced. While Lively agreed to identify which of the 38 documents had allegedly been produced by third parties in an unredacted form, she did not attempt to do so until October 16th. So they're trying to run out the clock. She then proceeded to file this motion a month after the close of fact discovery, fashioning it as a sanctions motion, attempting to avoid the untimeliness of her motion to compel. I just think she just wants money at this point, and this is just a cheap, harassing money grab, in my opinion. Another footnote. Number 3. Indeed, 5 of the documents listed on Exhibit A to Bender's declaration were produced for the first time after the court's August 27 order, and therefore necessarily could not be the subject of that order. Footnote number 4. Lively's omnibus motion to compel only asserted that the Wayfair party's redactions were improper because they failed to indicate the basis for withholding information in conformance with the ESI stipulation document 553, page 24. In response, the Wayfair parties agreed to modify their redactions in their previous productions as necessary to replace black box redactions with text box redactions, indicating the reason for redacting were applicable and reproduce the affected documents. This is crazy, y'all. Document 610, page 13. Lively's reply did not mention the redactions at all. Docket 464. The order acknowledges the Wayfair parties' agreement to comply and modify the redactions to replace black box redactions with text box redactions, and ordered them to do so by September 2, 2025, docket 711, pages 2 through 3. Third page. Even if the court were to consider the substance of Lively's motion to compel, it should be denied. Pursuant to the joint stipulation of the Protocol for Discovery of Electronically Stored Information and Hard Copy Documents, docket 212. Nathan redacted non-responsive material from documents, including those related to her other public relations clients and her personal life. Does anybody think that she just wants to get the juicy details into everybody's personal life and just dig and find something else to harass people? My opinion only. Hi, Girly C. Thank you for tuning in. Where are you from? Sorry if the mic is all messed up. It's my phone. I'm not fancy yet. Okay, let me see where I left off because my ADD brain. In personal life. Lively has not demonstrated that the redactions on the 38 challenge documents were overbroad, or if they were that the entire document must be produced without redactions. Lively cherry picks some of the 38 challenge documents. Where have we heard cherry picked before? Philippines, shout out to the Philippines. I hope you guys are okay after that typhoon. I will tell you, I do have family in the Philippines, in Bohol, and they said that they fared pretty good. But I haven't heard from them in the last 24 to 48 hours. So I think maybe internet and might have been knocked out. But I hope you guys are doing good over there. And I hope everybody's safe. Thank you for joining in. Okay, so Lively cherry picks some of the 38 challenge documents she contends demonstrate that the redactions somehow deprive Miss Lively of relevant and responsive material necessary for Miss Lively to prosecute her claims. Lively's selections prove the opposite. Lively's primary claim is that Nathan improperly redacted information regarding the digital campaign. In the document, Bates labeled Nathan 000, a whole bunch of zeros, 885. Bender declaration, there's abbreviations I don't even know how to say. But Lively neglects to mention that the same document, originally produced on July 16th, was reproduced by Nathan on August 22nd without any redactions. And then again, Benson Declaration, is this Exhibit 3-4? Is that how you say it? Lively also fails to disclose that the same document was produced without redactions by Justin Baldoni, Jamie Heath, and Jen Abel as early as July 16. Oh, okay. I think these are all exhibits because there's several exhibits that are the same thing. Okay. These are exhibits 5, 7, and 8. In addition, Lively herself produced the same document without redactions because it had been subpoenaed by her own company, Van Zandt, from Jones' work before she filed her lawsuit against the Wayfair parties. Benson Declaration Exhibit 9. Similarly, Lively also misleadingly, I love that word in this letter, asserts that Nathan's phone records were improperly redacted, ignoring the later reproduction of an unredacted set. Nathan's phone records from May 1, 2024 to February 18, 2025. And I think that is way too much time to, I just really wish they didn't go further into like January, February, because we all know this is hogwash of a smear campaign. And she did it to herself, in my opinion. I'm sorry, I'll continue reading. To February 18, 2025 were produced by as required by the order. All redactions were removed from Nathan's phone records and reproduced by September 11, 2025. Regardless of whether Nathan personally produced an unredacted version of a document bearing her Bates number prefix, if an unredacted version of a document was produced in the litigation by anyone, Lively reasonably cannot argue that she was deprived of critical evidence. So if she got it from Jamie, if she got it from like 2, 3 other parties, is it really depriving her? Or is it just depriving her of more attorney's fees that she can charge everybody? Because that's what I think is happening here. Again, I just think maybe this is just a money grab because she's just lost her paycheck. She basically spent her paycheck from the movie on legal fees if Ryan Reynolds is not covering all this, and who knows. Lively's argument that some of these documents on her list are essentially unreadable is also unpersuasive. Lively's argument is based on a mischaracterization of Nathan's deposition testimony. Okay, how many times have we heard this term mischaracterized? Oh my goodness. The writing is on the wall. Can anybody see it? Blake, just looks bad. I'm so sorry. Nathan's deposition testimony about one of the documents, document 901, Bender Declaration Exhibit O and P. When pressed by Lively's counsel, Nathan merely admitted that, as with all redacted documents, including those produced by Lively, it is possible that it might be a little bit easier to read if the document had not been redacted. Well, duh. I want to read Lively's redactions. Hey, can you just give me Taylor Swift's text messages? You can redact whatever you want on that. I just want to see it. I just want to see and read in between the lines. Importantly, Lively does not argue, nor is it the case that she was unable to question Nathan about the unredacted and only responsive portion of the sole document she claims was unreadable. For the foregoing reasons, defendant Melissa Nathan respectfully requests that the court enter an order denying Lively's motion in entirely. I think Lively should be sanctioned for these frivolous filings. And I'm clicking on my phone. I'm so sorry, guys. I'm going to read from the chat real quick, and then I'll read the fifth footnote. I really thank you guys for joining. Philippines flag, love it. Thank you. Some parts of the north still have no electricity and internet, but we're okay. Oh, good energy, good vibes. Hope everything is okay. I wish they face criminal charges, but knowing Wayfair Party, they might just pray for Blake's team after they won against her. You know what? That is a really good point. Does anybody feel that these people are just naturally passive and humane and just they don't want to fight? They're just advocating for the truth and transparency, which, and you know what, honestly, patience, because check out one of these exhibits that Blake wanted, and this is in several exhibits that she has brought up, but in one of these exhibits, it has text messages from everybody. And this one is from Jamie Heath in regards to, it looks like Sony's support or something like it. This is dated August 15, 2024 at 1:14 in the morning. I'm not sure if that's West Coast, East Coast, somewhere coast time. It says, I spoke with Justin. Here's my honest thoughts. No, it's not perfect. There is some misinformation here for sure. And yet, I see this as a win. Let her be praised by Sony. Who cares? It's not a bullet at us. Finally, there is an article that is not directed at Justin. And who knows, maybe Blake and Ryan forced Sony to put something out on their own behalf. Even if they did it on their own volition, who cares? The industry knows the truth. We know the truth. Whether or not 12 or 100 fans read that and believe it, it does not matter. As I've said many times, Sony's job is to promote the movie and to make as much money as they can. And I think this is important because Sony's job was to promote the movie and make as much money as they can. But we have to remember who was also going to profit at this. It wasn't only Blake Lively and her producer credit, it was no more. So the more money that this movie made, the more money went to nonprofits and gave back to a community that desperately needs it. Because there are so many of us, DV, SH, SA, R, MST, anybody who's just, there's a large community and it's all taking a helping hand. And I really believe in this mission. I also have a nonprofit. My nonprofit is called Seven Farms, and it benefits children who've experienced intense trauma, and it provides donations for equine therapy. So it's basically these children get mental health therapy and trauma therapy while they're riding horses. And so it's kind of like pet therapy meets talk therapy and breath work and mindfulness all in one. and it is amazing. My spectrum child experienced intense trauma, and I'm so sorry for deviating. I can get back to the text messages, but I just want to make this point. My spectrum child experienced intense loss with the rest of us when he lost his father suddenly and traumatically. And he went nonverbal. I'm so sorry to cry. He went nonverbal, incontinent, night terrors, problems sleeping, just fits. And I really struggled with finding art therapy, play therapy, any type of child therapy that could help get them out of this really tough place, because it's not like you can, take a child to a therapist and you just sit on the couch and you talk. These are really specialized therapies that, not many people do, and there's a lot of need for them. So when I found out about equine therapy, not only for the benefits of the autism community, but also with trauma and PTSD, like I also suffer, which is why I'm up all night. And I thank you guys for being with me. Um, it's a wonderful therapy, and there was a lot of progress. And I enrolled my 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 middle son and my youngest son. Unfortunately, my youngest son was just too young to handle. Might have ended up in a bullpen a couple of times as I was chasing him around a ranch, but that's okay. My spectrum child got the help that he needed. He became verbal, consonant, no night terrors. We started positive affirmations, positive songs. I really believe that he made a very beautiful and quick recovery. And I really do believe that equine therapy put our family back together and healed us in ways that we could have never been healed. So I basically make fairy gardens. They're like fairy lights and plants and little cute things that light up your plants. And I sell those. The profits, some of it goes to me, but most of it goes to right now Healing Hearts Ranch LLC in California. If you don't want to buy a fairy garden, but you just want to donate like $1 or something, I've already talked to them. They will make whatever donations work. I was hoping to sponsor a child for a month's worth of therapy, which is $200. Um, I don't actively advertise like I probably should, because I'm a little embarrassed by it in my personal story, and I feel like I'm begging, but I just want to highlight. So I have to get over my own ego and fears about that. But again, thank you. Now I'm going to get back to these text messages. If you guys want any more information on my nonprofit or my personal story with trauma or my children's personal stories, I am happy to share, as long as my story helps someone else. That's all that matters in this world. And that's why I'm so grateful for Wayfair, that they exist, because their whole concept was what I've been dreaming about my whole life. Oh my gosh, you have a foundation where you're not only making a money and putting food on the table for your families and being very successful in your industry, you're also giving a hand up to those who need a hand up, not a hand out, like Blake Lively wants in her $161 million. Again, in my opinion, allegedly, but thank you and blessings to Wayfair and good vibes. Sorry. Okay, back to this text message. Sorry, I have ADD, so I go on a lot of tangents. I'm just gonna check in with the chat. My phone keeps going dark. I'm just gonna scroll up. I'm so sorry to hear that. I'm glad you're able to get help from him and he recovered. Hearts. Thank you so much, and hearts to you. So I'm going to go back to this text message. I think we were at whether or not 12 or 100 fans read that and believe it, it does not matter. As I've said many times, Sony's job is to promote the movie and to make as much money as they can. That's the only reason why we partnered with them. And they are doing just that. I don't expect them to be any different than who they have always been and who they are. And the fact that they are cozying up to Blake also makes sense. If they are even doing that, they are a business that is protecting their own bottom line. That is very important. They are protecting their bottom line. What Wayfair stands for is what Wayfair stands for, and I don't expect anyone else to. If we can get some things corrected, great. If not, who cares? And honestly, I don't care who Sony nestles up to. As long as they can put out a movie of ours and make money so that we can be Wayfair and do what we do, then I am good. Let's not lose sight of the big picture. Right now, that's keeping bullets away from you, Justin, away from me, and away from Wayfair. And if that comes at the expense of her being praised, then so be it. And that is the win. And yet I get it's frustrating. Whoo, that is frustrating. And basically, all of these text messages and these last exhibits, they're all the same. I did find this text message. It looks like it's from Justin Baldoni when he was hospitalized, August 15th, 2024. It says, this is from Justin Baldoni to Jennifer Abel. I'm sorry, I don't have the capacity just right now in this moment to be the bigger person and to do that. You have to remember that it was her betrayal that landed me in the hospital. It's been devastating to me. Does that not sound like harassment? Does that not sound like he could have a case for like damages if the shoe were on the other foot? No wonder they sued the New York Times for like defamation and all this other stuff. Okay, I really wanted to read you guys this last email that was an exhibit, and it's pretty interesting because it talks about metadata. And then this will be my last read for the night, and then I think I'm going to cuddle up with my German Shepherd, who is outside the door waiting for me because she's a big baby and not brave. So here is an email from Kim, from Leiner, Friedman, and Tatelman, and Cooley. And they were talking about these deposition times, and then that there's a discrepancy, and that Mr. Gray Stone wasn't served properly or for service for deposition, and they're fighting. So this all starts on October 3rd, and this is all part of the same email thread. Manat says, Miss Lively intends to question Mr. Greystone, and I'm not sure who Mr. Greystone is. I didn't do any research on the guy before I went live. I just kind of had some anxiety and decided that I should read some court documents in the middle of the night with y'all. So Miss Lively intends to question Mr. Greystone within the scope of his direct examination and reserves time to do so. I'd be happy to discuss further on Monday. So these people are going at it. Manat and Friedman's firm, but this email thread dated October 7th from Kim to Sarah, and Sarah is with Manat. So it says, Sarah, this email follows our discussion of certain deficiencies in Miss Lively's document production, which came to light at Mr. Stone's deposition. Please let me know at your earliest convenience when we can meet and confer on the 6 items listed below. So I'm not sure if you guys heard about this. Let me know in the chat if you've heard about any of these discrepancies in Miss Lively's thing. Number 1, Exhibit 6, BL something at page blah 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 at 1:03 a.m. 1:03 a.m. is insomnia hour, right? She attaches a document titled IEWU BL Protections page. As discussed, this attachment was not produced. Please produce the document, include the required metadata. Ooh, ooh. And then there's some writing in red. It says, we have, and I think this is Sarah's response in red, because it kind of gets hard to tell. We have discussed this issue on multiple conferrals with other attorneys from your firm. Plaintiff produced full families of all documents. So the extent that there is a missing child, it is because the underlying document was not saved to plaintiff's iCloud account and therefore not available for collection. Why was it not saved to Blake Lively's iCloud account? And what is Exhibit 6? Is this BL blah 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 blah? If someone knows what that is, it'd be very interesting. But why is it talking about a missing child? Is that like a missing? Maybe they misstated something. But I'm thinking like missing child, like lost child. Like Amber Alert or something in the US. And then point number 2, Exhibit 5 is Exhibit A to plaintiff's second amended complaint. As discussed, Ms. Lively did not produce the document. We are aware that the document is included within Wayfair's production, as you pointed out, but Ms. Lively did not produce it. Please do so and include the required metadata. The response in red is, this document was produced at BL, and then they have a whole bunch of numbers after it. Point number 3, several of the Stone depositions exhibits you marked are alleged offers or contractual documents, but are heavily redacted as non-responsive. What are these contractual documents? I want to know what those are. If you intend to rely upon these documents as evidence in support of Miss Lively's damages, they must be produced in their entirety. It is improper for Miss Lively to selectively, don't you love all of these words? Cherry pick, selectively, mischaracterized. Ooh, I love those college words. Selectively determined what is relevant within the contracts. So I think they're referring to damages, maybe something. If it's an offer, I just want all the evidence right now so I can just read it. Let's go to trial right now. There may, for example, be relevant limitations on compensation or performance. This does have to do with discovery. And she doesn't want to show the money. Ooh, she doesn't want to show the money. The documents, in my opinion, allegedly me, the documents have already been marked attorney's eyes only. Please reproduce in an redacted form exhibits 17, 18, 19, 23, and 24. You think those are movie contracts, hair contracts, speaking contracts, Ryan Reynolds contracts? Maybe they're doing some, well, I guess they really don't work together, do they? They market, but they really don't do much. The response in red, many of these contracts contain confidentiality provisions that require approval from the contracting parties to disclose their contents. We will confer with the contracting parties to determine their willingness to produce the agreements without redactions. And this is point number 4. And this is what caught my eye, because this is the 30-point list. And they're talking about metadata, the required metadata. Listen to this. Point 4. The 30-point list that appears to be cut and pasted into paragraph 20 of Miss Lively's complaint was not produced. I'm going to say that again. The 30-point list that appears to be cut and pasted into paragraph 20 of Miss Lively's complaint was not produced. Why? Why wasn't it produced? Was it not produced because it wasn't given to Wayfair? I might have to plug in my phone. It might be dying, but I want to continue this conversation. But does anybody find that interesting, that discrepancy between the 17-point list and the 30-point list? I'm going to be right back. I'm going to grab a charger. There's still 2 more points I have to read on this. I'm still here, you guys. All right, where are my other 3 viewers from? If you can say. We've got the Philippines. We've got Seattle. What time is it in the Philippines? Is it like tomorrow at like 1 p.m., 1:30? I should know because I text my dad at this hour and we usually talk about stuff. Okay, I'm going to hold you guys. So if the sound gets weird, I'm holding you and I'm holding a laptop. We're going to make this work. Somehow, some way. Thanks, guys, for your patience. 6:30 on a Tuesday. 6:30 p.m. on a Tuesday. Oh, nice. I hope you guys had a good dinner or having a good dinner. Okay, I'm going to move myself. So is the chat a fan of Blake Lively, or were you a fan of Blake Lively before this lawsuit, and has it changed your mind? So point number 4, the 30-point list that appears to be cut and pasted into paragraph 20 of Miss Lively's complaint was not produced. Please do so and include the required metadata. And then in red, the response was, this document was produced at BL blah 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 and BL blah blah blah. But I kind of want to see what that metadata was, which I think they bring back at point 5, if I read this correctly. Are these the same numbers? It does not look like this exhibit or evidence is the same numbers as above, but point 5, BL 22331 tag 37 is a text exchange between Mr. Zavella and Miss Lively. The entry on 11/15/2023 at 7:04 p.m. purports to attach a document titled IEWU BL protection pages. Slightly different from the title of the document referenced in Exhibit 6. So, are there different versions of this exhibit or this document or whatever they're talking about? Why are there slightly different titles? Was it altered? Was it edited? And then in red, the same explanation provided in response to number 1 applies here. So what was the response to number 1? We have discussed this issue on multiple conferrals with other attorneys from your firm. Plaintiff produced full families of all documents. So the extent there is a missing child, it is because the underlying document was not saved to plaintiff's iCloud account and therefore was not available for collection. So maybe Lively should have been aware that she should have saved all of her documents and whatnot in anticipation of litigation. Maybe we should sanction her because obviously she didn't save anything, so this document cannot be found. But can it be found on our computer? Can it be found in another lawyer's office, whoever created it? I don't know. And then I'm just looking at something real fast. So I guess it didn't have different dates of metadata. Number 6, and this is a very long email thread, but it's just very interesting. And then the last point that they pointed out is to the extent that there are multiple versions or red lines of the alleged protections or requirements document, which were apparently stored on Miss Lively's computer or other electronic devices, they must be produced. So if Jamie Heath has to produce all of the versions of the birth video on his phone, Blake Lively should be able to provide all versions of all of these 30-point lists, 17-point lists, or whatever they're talking about, as well. It should be equal. And if she didn't, then why can't we say that she did evidence spoliation? In my opinion, allegedly. What do you guys think? Do you think that it sounds like maybe she's misplaced some certain important items that could be helpful to the defense case and hurts her case even more or sheds her in a worse light? I'm not sure how worse light she can get. This is already pretty bad. So, and the downfall, this long forever downfall is just amazing to me. So number 6, they must be produced. We note that no such documents appear on Miss Lively's privilege log. The documents weren't reported on a privilege log, and then they weren't found anywhere else. That's interesting. So they had this email exchange, and you can see, I think this is exhibit 2 or 3. This is dated October 7th, by the way, if you wanted to see what they wrote. And then there's another email from Lyman's firm again, and this looks like it's in response to Manat's answers, right? And I guess I should have led with this, but they're just going back and forth. Point 1 again, we understand this issue was discussed generally, and I'm raising again, but this time for only two specific documents. Ms. Lively contends that the protections document is highly relevant to this litigation. Therefore, all of this document must be produced. Exhibit 6 to Mr. Stone's deposition is one such document. So they have something, right? Your statement that the document is missing because the underlying document was not saved to Clinton's iCloud account should not end the inquiry. How come they didn't compel her to do all this? By default, Apple Page's word processing program automatically saves documents as you work on them. Therefore, the document was either saved locally or on an iCloud at some point in time. Your statement that the document was not saved on iCloud is not specific enough. Let's see. Was it ever saved to Playton's iCloud account? If it was saved to Playton's iCloud account, then advise when it as deleted. Oopsies, something deleted. In addition, advise if the document was ever saved locally on one of the plaintiff's devices, her phone, iPad, computer, or laptop. Did you look on the devices for these documents? If it was not available, when did the plaintiff delete it? Did she delete it in November of 2024? Did she create it just out of thin air just for the CRD and then deleted it? What happened? Why? Where is it? So and there's another response. Oh, here it is. Here's a good one. Plaintiff has claimed work product protection as early as May 19, 2023, as on her privilege log, reflecting that as of that date, she anticipated litigation. This is going to get, this is just, oh gosh, this is just, ugh. Therefore, please explain why all documents were not retained and preserved that were dated or created on May 19, 2023 or thereafter. Why don't they just go over with her for the the exploration of evidence? Please let us know when we can expect a response or if court intervention is required. Where was court intervention? They must have gotten it. And now they're fighting over this 30-point thing. We have several issues with response. First, the metadata for the 2 pages you listed above reflects the creation date of July 23, 2025. The 30-point list in the second amended complaint first appears in the CRD complaint on December 2024. And if the complaint alleges that this list existed as of January 4, 2024, obviously the July 23, 2025 created document cannot be what Ms. Lively alleged read on January 4, 2025, as it was not created until July 2025. Did they produce fake evidence? Because that's what it sounds like. Does it sound like that to you? Created July 2025. Why? I want to know why. Second, the 2 documents produced as BL 3846-1 TAC 462 appear to be screenshots of yet another document or documents that was not produced. Note the envelope legend on the bottom of page 38461. Where is the original document with the metadata as required by the ESI protocol? Was it destroyed or deleted? If so, when did that occur? Does anybody else think that Blake Lively just wanted to accuse them of evidence spoliation because she was doing the same thing? Does this does this sound like she might have deleted evidence? Where is it? How come she didn't give it over? I'm shocked. Okay, I'm not shocked. But yeah, okay, yeah, I am shocked. Like how why? Why? It's not, because they would find out if stuff was deleted. Third, the title of this document is cut off. It reads BL. Blake Lively updated LS list of pro pages 388KB. It also has a timestamp in the left upper hand corner but it does not have a date. Where is the missing information regarding this document? Finally, if this document was destroyed, please advise when it was destroyed and explain why it was not preserved, given Miss Lively's claim that she anticipated litigation as early as May 19, 2023. Why would she anticipate litigation as early as, isn't the start of set? Isn't that one of the first days of set? May 19, 2023? And she was already planning on litigation for wearing shorts. I'm just going to put it out there. I think she's wearing shorts in that birthing scene. And I think the cameras, I hope the cameras caught that. And they are just hammering them. The same issue exists with respect to this document that exists with respect to number one above. And then here it gets really serious. The comment raises issue regarding the adequacy of plaintiff's privilege log. The description of many of the items listed on the log read email providing. And then it says, or reflecting legal advice of Sloan, Offer, Weber, and Dern, LLP, concerning on-set conduct. You now claim some of those include versions of the protections or requirements document. We note that BL blah 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 is Blake Lively's updated Lindsay Strasberg's list of protections. Updated list? Is Miss Strasberg's list, which Blake Lively revised, on the privilege log? Which entry is it? This reveals that your privilege log is insufficient as it does not allow us to evaluate your claim of privilege. Does this not sound familiar? It sounds like Blake Lively took all this and then spit it back out at Wayfair, honestly, in my opinion, allegedly. For example, the documents with the titles reflected in numbers 1 and 4 above are not privileged. And if a document bearing that title was withheld on the grounds of privilege, we are entitled to challenge it. Accordingly, Ms. Lively must 1. Identify each of the entries on that log that contain summarize or attach any versions of the protections or requirements, documents, and identity as such. 2. Provide the author of each document or revision. 3. If an attachment, provide the name of the document, e.g., IEWU BL protections pages, so that we may properly evaluate your claims of privilege. And 4, provide descriptions of other than simply concerning on-set conduct or post-production conduct. Gotta love that post-production conduct that you did not have to be a part of, allegedly, in my opinion. These issues have caused us to examine your privilege log more closely. Who is Season Kent? Cami Espar, Phil Singer. In addition, you have claimed a common interest privilege with Colleen Hoover. Miss Hoover recently testified that she never contemplated filing an action against the Wayfair parties. Accordingly, this document must be produced. Dun, dun, dun. So that was October 13th. And then this is from Michaela. And there are just, this next one just looks like they're, sorry, I'm just reading this. It looks like they're talking about deadlines and discovery deadlines. Oh, here's an important, this is just going to sum up the whole email for this last one. Miss Lively will not engage further regarding the Wayfair's dependents' belated attempts to raise new issues as its claimed discovery deficiencies. They're not even going to talk about it. Nope. Door shut on that one. Oosh. Man. That was exhibit 2. It's 11 pages. It's in reverse order. So the newest is up first and it's dated October 22nd. But I am just bewildered that Blake Lively can accuse the Wayfair parties of, destroying evidence when clearly in October there was a concern about evidence not being produced. So who's destroying evidence and who's withholding evidence? So honestly, right now, it just looks like a he said, she said fight about producing evidence, right? Sorry, that was my charger. Um, so these new sanctions, do you think it's distracting from her wrongdoing now? And this is just going to be a bloodbath, y'all. And now that this is released, do you think Blake Lively is going to get really, really upset? Because I'm sure other creators are going to read this. I mean, this is pretty juicy stuff. What do you guys think about everything? And what have you just heard? And what you guys just heard? Juicy? I mean, do you think Wayfair should push the issue? Maybe they got everything, right? Or are they going to continue to push this issue? I don't know. But it's definitely interesting. I'm just going to go over this text messages that everybody gave Blake Lively. These are all redacted. There's no redactions here. And they're just talking about how upset they are about everything. So all the stress put him in the hospital. And that sucks. And if anybody out there has a chronic illness, you know what stress does. And I think they knew that. And I think, in my opinion, they went after him just to physically hurt him. This is physically hurting people. It physically put him in the hospital. They should sue for harassment, have her pay his medical bills for this stupid thing, for everything that they did. And even in this text message, Justin is not out to hurt anybody. And there hasn't been one lie that has come out of his mouth. All he's been doing is singing the praises of you and everybody else and sticking to the message of the movie. I don't even know who this is to. Oh, Jennifer Abel. So, yeah. I mean, anybody else tired too of Blake Lively's antics and anybody just want to see her win finally or hush up her filings? But I definitely think things are going to be very interesting when the MJOP and the summary judgment all come out. So I'm going to try to relax now that it's going to be the witching hour and it's probably going to freak me out. If I can't sleep, I'll probably come on live again and do a paranormal podcast. I haven't done a paranormal podcast in a long time. Well, in about a week or so. So I don't know if anybody has any ghost stories or any legends they want to send me. We could talk about it. But I just want to thank you guys from around the world for joining in at 3 a.m. It was a pleasure talking with you guys and reading these court filings. And I will probably be on tomorrow live as well. And maybe this is just a good time and it works out for everybody. I've got insomnia up all night. I'm also a night shifter. So when I do go back to work, I'm going to be up all night anyways. So, this has been fun. Thank you guys. Like, subscribe, comment, give me feedback. I enjoy it. Give me hate comments. I don't care. It's all makes me a better person. It all helps this podcast and this YouTube channel. Again, thank you around the world from the bottom of my heart. Thanks, guys. Have a good night, and I'll see you next time for some iced tea or maybe some coffee because we might need it. All right. Bye, house guests, and have a beautiful night.